Hello and welcome to Workers Comp Unwrapped, the podcast that simplifies workers' compensation for physicians. I'm your host, Max, here to give you clear, actionable insights to navigate the medical legal side of workers' comp. So let's get started. Welcome back to Season 2, Episode 10 of Workers Comp Unwrapped with Max and Aisha, who has 15 years of experience in the workers' comp industry.
Yeah, it's great to be back.
Today, we are talking about understanding how defense attorneys approach contested claims, their impact on treatment approvals, and how providers can work with them effectively.
It's going to be a good one.
Think of this deep dive as your cheat sheet to understanding the defense attorney's playbook. Why does this matter? Because defense attorneys have a lot of influence over whether your treatment gets approved, and that directly impacts whether you get paid.
Yeah, I'd say it's pretty important.
We're talking potential delays, disputes a ton of paperwork. But if you know what the defense attorney is thinking, it helps you navigate the system and avoid some of those roadblocks. So today we're on a mission to figure out some practical strategies to help you get those treatment approvals and keep those reimbursements coming in. So let's get started. What's the deal with defense attorneys? Who are these people?
Defense attorneys are the legal representatives of employers and insurance carriers. So in workers' comp cases, they're there to protect the employer and insurance company. Their main goal is to make sure their clients don't end up paying more than they absolutely have to.
So they're looking out for the bottom line. Makes sense.
Right. And they're also there to make sure everything stays within the rules and regulations of the workers' comp system. So that means they might challenge claims or treatments that they think are excessive, maybe even fraudulent, or if the treatment doesn't follow the guidelines.
So let's say, hypothetically, I have a patient who files a claim weeks after they say they were injured. No witnesses, no record of them going to the doctor right away. Would that kind of situation trigger a defense attorney to get involved?
Absolutely. Anything that seems inconsistent or doesn't add up raises red flags, and they're going to start digging to see if the injury is legit and if it's really work-related.
Okay, so it's not just disputed claims that bring in the defense attorneys. When else do they typically show up?
You'll definitely see them with disputed claims, but also with more complex cases. Think multiple injuries, pre-existing conditions, or when it's unclear exactly how the injury happened. They're also involved in treatment denials, fraud investigations, and of course when it's time to work out a settlement.
So basically, anytime things get complicated or there's a lot of money at stake, the defense attorneys are likely to enter the picture. They're like the investigators of the workers' comp world. But what does that investigation actually look like? What are their strategies when they're looking into these contested claims?
Well, as we said, they are the masters of investigation. They're going to meticulously examine every detail of a claim to see if anything seems off. Maybe there are gaps in the timeline, inconsistencies between what the worker says and what their medical records show, or anything that suggests the injury might have actually happened off the job.
So they're looking for holes in the story, basically.
Exactly, and a huge part of what they do is focusing on medical necessity. They'll work with utilization review to determine if the treatments you recommend are really necessary based on California's Medical Treatment Utilization Schedule, or MTUS.
Ah, yes, the MTUS.
Yeah.
So let's say I recommend surgery for a patient with a back injury. Is that something a defense attorney might challenge?
Possibly. They might argue that surgery is too aggressive at this point and that less invasive options like physical therapy or injections should be tried first. They're looking for the most conservative and cost-effective approach.
Okay, I'm starting to get a sense of their mindset here. What else do they look at when they're evaluating a case?
Sometimes they'll request an independent medical evaluation, or IME, to get another medical professional's opinion on the injury and the treatment plan.
So kind of like a second opinion?
Exactly. The IME doctor will confirm the diagnosis, see if the patient has reached maximum medical improvement, MMI, and determine if they need more treatment.
It sounds like IMEs can have a big impact on how a case unfolds.
Oh, for sure. Defense attorneys can also challenge whether an injury is really work-related. This is especially true if someone had a prior injury or if there are different versions of how the injury happened.
That makes sense. So if someone had a history of back problems and they say their back pain got worse after lifting something heavy at work, the defense attorney might argue that injury wasn't really caused by the work incident.
That's a great example. It's important to remember that everything a defense attorney does is ultimately about protecting their client's bottom line. So they're always trying to find ways to keep costs down, whether that's by arguing against certain treatments or negotiating lower settlements.
So how does all this play out for providers like me? What kind of impact does the defense attorney's role have on what I do on a daily basis?
Well, the first thing is they're going to be looking at your medical records very, very carefully. They're looking for inconsistencies, missing information, anything that doesn't follow the guidelines.
So what should I expect in terms of actually interacting with defense attorneys? What kind of requests or questions should I be prepared for?
They might ask for more documentation to justify your treatment plan, and they'll definitely ask you to explain how your recommendations fit within the MTUS guidelines. Sometimes it can feel like you're constantly being questioned.
So meticulous record keeping is essential. Everything needs to be clear, concise, and well documented.
Absolutely. And delays in treatment approvals are a common problem.
I've heard those delays can be a nightmare. What causes them?
If the defense attorney challenges a treatment request, it triggers a review process that can really drag things out. This means your patient has to wait longer to get the care they need, and you have to wait longer to get paid.
So it's frustrating for everyone, especially the patient.
It really is. And sometimes you might even get a request for a deposition or be asked to testify.
So I might have to explain my treatment rationale and how the injury is work-related under oath.
That's right. And remember, defense attorneys are involved in settlement negotiations too, so the outcome of those negotiations can impact your patient's ongoing care.
Meaning, they might try to negotiate a settlement that limits or cuts off future medical benefits.
It's definitely a possibility. It's good to be aware of how those negotiations could affect your patients down the line.
Well, this all sounds pretty challenging, but I imagine there are ways to make the process smoother. Is there a way to work with defense attorneys more collaboratively?
Absolutely. The key is to understand their perspective. By knowing what they're looking for and how they operate, you can actually turn these challenges into opportunities to work together.
Okay, I like where this is going. What are some practical strategies I can use to work with them more effectively?
Well, clear and thorough documentation is your best friend. The more detailed and comprehensive your records are, the less likely they are to question your recommendations.
So what should I be making sure to include in those records?
Accurate diagnoses, a clear explanation of why you're recommending that treatment evidence that supports the medical necessity of the treatment and documentation of any prior treatments the patient has received and how they responded.
So don't leave anything to chance.
Exactly. Now, let's say you do end up in a deposition. Being prepared is crucial.
Any tips on how to handle that?
Review the case files thoroughly beforehand so you're not caught off guard by any questions. During the deposition itself, stick to the facts and avoid speculating or giving opinions outside of your area of expertise.
Stay calm, stay focused, stay in my lane. Got it.
Exactly. And understanding their goals can really help you approach the situation strategically. Remember, their primary goal is to protect their client's financial interests.
But that doesn't mean we can't work together. We both want what's best for the patient.
Exactly. Just focus on presenting the medical evidence clearly and objectively, and try to avoid getting pulled into emotional arguments.
That makes sense. Any other tips for building a better working relationship?
Communication is key. Respond to their requests promptly and professionally. That builds trust and keeps things moving smoothly.
So no ignoring their emails or putting things off.
Right. And make sure your treatment recommendations are aligned with those evidence-based guidelines like the MTUS. That makes it a lot harder for them to challenge your decisions.
Follow the rules, do my research, and be ready to back up my recommendations with solid evidence.
You got it. Now, even when you do everything right, you're still going to run into roadblocks sometimes. Delays in approvals are a big one.
Ugh, those delays. What can I do when it seems like the defense attorney is dragging their feet?
If the delay is putting your patient at risk, you can advocate for an expedited review. Clearly explain the situation and emphasize why a faster decision is so important.
So don't be afraid to push back a little when it's really necessary.
Exactly. And those endless requests for documentation can really eat up your time.
Yeah, I can only imagine how much paperwork is involved in some of these cases. Any advice on how to handle that more efficiently?
A good organizational system is key. Keep your records organized and easy to access. That way you're not scrambling when they ask for something.
So a well-organized electronic medical record system is a must.
Absolutely. Now, I know getting called for a deposition can be stressful. It's natural to feel some pressure when you're being questioned under oath, especially when the outcome of the case could depend on what you say.
Sounds nerve-wracking. Any tips on how to stay calm and confident in that situation?
Practice makes perfect. If you have access to legal counsel or a colleague who's been through a deposition before, Do some mock depositions to get comfortable with the format and the kind of questions you might be asked.
So basically rehearse it beforehand. That's a great idea.
It can really help. Now, sometimes it's helpful to see these concepts in action. So let's take a look at a case study where collaboration with the defense attorney actually led to a good outcome for everyone.
Love a good case study. Let's hear it.
So imagine a provider recommends some advanced pain management treatments for a patient dealing with chronic pain after a work injury.
Okay.
The defense attorney denies the request, saying the documentation doesn't clearly show those treatments are medically necessary.
Classic documentation issue.
Right. But instead of getting frustrated, the provider went back, looked at the denial, and gathered more evidence to support the recommendation. They added detailed progress notes, diagnostic imaging results, all that good stuff.
So they basically built a stronger case.
Exactly. And when they were called in for a deposition, they used that opportunity to really explain their rationale for the treatment and how it all aligned with MTUS guidelines.
So they got to tell their side of the story.
The defense attorney, after seeing the extra evidence and hearing the provider's explanation, agreed to have the patient get an independent medical evaluation.
Bringing in that outside expert for a fresh perspective.
Right. And the IME doctor confirmed that those advanced pain management treatments were necessary.
Cool.
The result: treatment approved, the patient got the care they needed, and the provider got paid.
That's a great example of how working together, even when there are disagreements at first, can lead to a win for everyone involved.
Exactly. Sometimes it just takes that extra effort and communication to get everyone on the same page.
Okay, so now that we've covered a lot of ground, what are the key takeaways here? What are the most important things I should keep in mind when dealing with defense attorneys?
I'd say the biggest one is always anticipate scrutiny. Those defense attorneys are going to be looking at your medical records very closely, so make sure your documentation is impeccable.
Got it. Be thorough, be accurate, and be prepared to back up your decisions. What else?
Professionalism is key. Stay focused on presenting objective, evidence-based recommendations and try not to get pulled into emotional arguments.
So stay cool, stay factual, stay professional.
Exactly, and don't underestimate the power of clear communication. Responding to their requests promptly and professionally shows them you're willing to work together.
Be responsive, be respectful, be a good communicator. Got it.
And remember, preparation is everything. Whether you're facing a documentation request, a deposition, or even just a phone call with the defense attorney, being prepared helps you feel more confident and in control.
So do my homework, know my stuff, and be ready to advocate for my patients in my practice?
Exactly. Remember, even though defense attorneys are there to protect their clients' interests, you both share the goal of getting the injured worker the best possible outcome.
That's a really good point. It's not us versus them. It's about working together within the system to help the patient.
Right. By understanding the defense attorney's role and approaching these interactions strategically, you can turn potential challenges into opportunities for collaboration.
That's a great takeaway. I feel like I'm starting to see things from a new perspective.
It can really be empowering. Even though the workers' comp system can feel complex and sometimes adversarial, you do have the power to make a real difference.
I love that. It's not about feeling powerless. It's about understanding the system and using that knowledge to advocate for my patients.
Exactly. And that brings us to the final thought for today.
Okay, let's hear it.
Even though you might see defense attorneys as adversaries, if you try to understand their role and work with them, you'll actually get much better results for everyone.
That's a really interesting way to think about it. Instead of butting heads, we can try to find some common ground.
Exactly. It's all about finding that sweet spot where you're advocating for your patients while respecting the rules of the system.
So as you're listening, I want you to think about what resonates with you. What kind of challenges have you encountered with defense attorneys?
And think about what strategies you can implement to make communication smoother, make things more efficient, and really help your patients get what they need.
Because at the end of the day, that's what it's all about, right? Making sure injured workers get the best possible care.
Absolutely. So keep learning, keep asking questions, and keep working to make a difference in this crazy world of workers' comp.
Well, I think that about wraps up our deep dive into the world of defense attorneys. I hope you found it helpful.
It's been great.
And to our listeners, thank you for joining us on this deep dive into the world of defense attorneys. We hope you've gained some valuable insights that will help you navigate the workers' comp system with more confidence and ease.
Remember, you're not alone in this. We're all in this together.
That's right. And as always, if you have any questions or topics you'd like us to explore in future episodes, please don't hesitate to reach out. We're here to help. Until next time, keep up the amazing work you do. Thank you for listening to Workers' Comp Unwrapped. If you found value in today's episode, share it with your fellow medical providers and healthcare specialists. For more information, contact us at lena.klein@medicallienmgt.com or visit our website, medicallienmgt.com.